Rules Committee will come to order. Good afternoon, and welcome back to the Rules Committee. I hope all of you had a good break. New Year marks a time for change. As Americans across the country bring new vigor towards our own resolutions, House Republicans are renewing our commitment to America. Vital to our agenda is a government that's accountable and an economy that's strong. These objectives are necessary to reverse the destructive policies the Biden administration has forced on the nation. One doesn't have to look far to see the results. Emptier wallets, a struggling economy, chaos on our border, rising crime, and emboldened adversaries. Yet these harsh truths will likely get worse as more ill-advised White House proposals move forward. It's why the Rules Committee is acting today to impose new guardrails and reverse 3 Democratic-led policies. First, we will take up H.R. 788, the Stop Settlements Slush Funds Act. The Biden administration has a penchant for resurrecting Obama-era practices, and their decision to reinstate settlement slush funds is deeply troubling. When the federal government settles a case, the restitution should be directed to the victims or the Treasury. Instead, this White House has reinstated the practice of funneling settlement funds to favored or politically friendly third parties. Unelected bureaucrats should not be able to line the pockets of their favorite progressive entities. It's an affront to the Constitution and allows those in power to reward their political cronies with other people's money. H.R. 788 will stop this abusive and corrupt practice. It will ensure that the federal government cannot direct settlement funds anywhere other than to government coffers or to remedy harm caused by the settling parties. It will ensure congressional oversight remains in place and will prevent the administration from evading Congress's appropriations powers. Our other 2 items are resolutions arising under the Congressional Review Act. Both of these measures will overturn deeply misguided Biden administration regulations, restoring the status quo. H.J. Res. 98 addresses the National Labor Relations Board, or NLRB's, effort to redefine the joint employer rule. If allowed to take effect, this rule will upend the franchise business model that's empowered entrepreneurship and job creation across the country. It will certainly make operational costs skyrocket and will eliminate countless small businesses and job opportunities nationwide. We don't have to speculate here, as a similar rule put in place under the Obama administration had far-reaching consequences across the economy, particularly for businesses using the franchise model. With the American dream already slipping from reach of so many over the past 3 years, the last thing people need is another liberal policy hampering the economy. Finally, S.J. Res. 38 addresses Congress's previously mandated Buy American requirements for investments to build our electric vehicle charging infrastructure. The standard supports U.S. industry and workers while rightly reducing our supply chain reliance on China. President Biden has decided to renege on these obligations. Rather than encouraging domestic manufacturing and taking steps to source these products from the United States, the Biden administration is seeking to waive Buy American requirements, propping up Communist China's control of industry production and subsidizing foreign adversaries that with U.S. dollars puts America last. House Republicans believe in the power and ingenuity of American manufacturing. We believe we should be constructing and sourcing our needs right here in the United States of America. The COVID-19 pandemic revealed the fragility of the global supply chains and the consequences of being complacent. The United States should be doing everything possible to build up domestic manufacturing capacity. Passage of Senate J. Res. 38 will be another step toward doing so. I now yield to our ranking member, my very good friend, Mr. McGovern, for any comments he wishes to make.
Well, thank you, Mr. Chairman. It's good to see you and good to see all my colleagues. Today's meeting covers 3 measures. First is H.R. 788, the so-called Stop Settlement Slush Funds Act. This bill stems from a fruitless Republican-led investigation based on meritless allegations of political bias when the Obama administration's Justice Department held big banks accountable for their predatory lending practices. Ultimately, Republicans' own investigation found no credible facts to substantiate their claims. But over a decade later, they're still harping on it by bringing this harmful and unjustified measure to the floor, which would weaken enforcement of environmental and consumer protection laws. House Republicans, after a full year in the majority, still have no new ideas or real agenda to help the American public. So they want to pass off this solution in search of a problem as some big, important new bill. It's not big, it's not new, and it's definitely not important. It's a waste of our time. Second is SJ Res 38. This resolution is House Republicans' attempt to weaken President Biden's Buy America requirements, allowing federal dollars to be spent on chargers made in competitor countries like the People's Republic of China, rather than increasing Buy America standards for EV chargers and the corresponding infrastructure. While Democrats and President Biden work to bring jobs back from China, Republicans are eager to do the bidding of billionaire corporations and ship jobs overseas to China. I'll just let that one speak for itself. Finally, we have HJ Res 98, a resolution that blatantly attacks the American workforce. This bill would weaken workers' ability to organize, collectively bargain, or otherwise hold their employers accountable. If we connect the dots here, these three measures have one thing in common. They give the ultra-rich an upper hand while hurting everyday people. What's worse is that all this legislation is just filler. The way this place has been run is so absurd. We're just coming back from the start of the second session of the 117th Congress, our first meeting, and we are facing a partial government shutdown by the end of next week. And although it's great that we have a top-line appropriations agreement, so the news reports, all you have to do is read the front page of the New York Times today to see that the Freedom Caucus is already throwing cold water on it. And as we all know, the MAGA extremists run this place. They tell Speaker Johnson what to do, and they call that agreement, this bipartisan agreement, a total failure. Marjorie Taylor Greene doesn't like it, and usually what she says goes around here. And now we are hearing that on top of these absurd bills, Republicans want to start impeaching everyone under the sun because, again, the MAGA extremists are upset that they aren't getting their way, and they want to throw another temper tantrum. So we are back, and it may be a new year, but it's clear that it's the same old Republican majority, trying to distract from their own disarray and division and doing the bidding of Donald Trump instead of working for the American people. And with that, Mr. Chairman, I yield back my time.
Thank you very much. Without objection, the prepared statements that our witnesses may have will be included in the record. I'd like to welcome our first panel, Representative Lance Gooden and Ranking Member Gerald Nadler from the Committee on the Judiciary. Representative Gooden, I welcome your testimony.
Thank you, Mr. Chairman. I appreciate the opportunity to speak in support of my bill today and thank the committee for considering H.R. 788, the Stop Settlement Slush Funds Act. It seeks to restore the constitutional safeguard of checks and balances among the three branches of government, which has been diluted recently, especially regarding congressional oversight. Specifically, my bill will repair a loophole that has been exploited by the executive branch agencies who have relied on it to circumvent and bypass Congress's exclusive constitutional power over the purse. This matter concerns all of us due to its long-term implications and scope of misuse by future administrations, irrespective of party affiliation. The loophole in question is the redirection of settlement amounts from federal lawsuits to non-governmental third parties under the policy of third-party settlements adopted by the Biden DOJ. This settlement policy allows agencies run by unelected and unaccountable officials to redirect settlement amounts to unrelated third-party organizations in government lawsuits against offenders. These settlements should be appropriately deposited with the U.S. Treasury or given to compensate the actual victims of these transgressions. However, the act of redirecting the compensation meant for the victims toward hand-picked donations to friends of administrative executives is an abhorrent misuse of power and discretion to rob deserving victims of their entitled compensation. Not only is there no authority vested in these agencies in the first place, but unauthorized redirection of funds is also an unconstitutional encroachment upon the exclusive congressional power of the purse. There is a clear and damning history of this policy's blatant misuse during the Obama administration, where it was used to circumvent Congress and fund specific programs that Congress had rejected. For example, in 2011, President Obama unsuccessfully requested Congress to fund electric vehicle innovation. After Congress did not grant this request, the Environmental Protection Agency used its settlement with Volkswagen in a pollution case to require Volkswagen to invest billions directed towards improving infrastructure, access, and education to support and advance zero-emission vehicles. Similarly, Congress specifically cut funding to HUD for housing counseling grants that would go to third-party activist groups. However, Obama's DOJ in 2014 entered into a certain mortgage lending settlements that went against Congress's funding decisions. These settlements circumvented congressional spending and policymaking authority and was an unconstitutional government overreach. The Obama-Biden administration also used settlements to direct funds to political allies such as the National Fish and Wildlife Foundation, the National Community Reinvestment Coalition, and the National Urban League in order to advance an agenda without congressional oversight. Even in the settlements with the 6 largest U.S. banks over their securities failures leading to the 2008 financial crisis, hundreds of millions went to unrelated things like warm water equestrian washing stations, propping up underfunded state pension funds, and a Real Housewives of New Jersey cast member. What makes this worse is that where and how the money was allocated and who made these decisions remain unknown. This external redirection maneuver allows any administration to direct or appropriate funds to any organization of their choosing by forcing the offenders to donate to a carefully tailored and pre-selected purpose or cause. In exchange for this donation, the offenders get a largely beneficial tax credit of $2 for every dollar since they technically made a donation. While this policy was effectively ended in 2017 by Attorney General Jeff Sessions during the Trump administration, it was revived by the Biden administration despite widespread objections. Since its revival, the administration has suspiciously remained tight-lipped about these dealings. The true extent of how much and how extensive these settlement funds are being redirected and to whom they are going to is unknown. Despite numerous correspondence attempts made by me and my colleagues, the Justice Department has not responded to any of our queries. Given DOJ's refusal to share any details despite congressional inquiries and the Biden administration's track record, one can only assume the worst. This bill, H.R. 788, eliminates the practice of slush fund settlements by prohibiting the federal government from entering into any settlement agreement that provides a payment to a person or entity other than the United States, with an exception for payments that are restitution, direct remedy actual harm, or constitute a payment for services rendered. The bill also improves transparency by requiring agencies to file annual reports with the Congressional Budget Office that describe how settlement funds are handled, and by requiring inspectors general to report to Congress on violations of the Act. This bill will help restore the state of permanent constitutional checks and balances that are required by the Constitution and intended by our foundational principles. This will put us back on track and no longer subject Congress's exclusive power of appropriations to the mercy of the administrator in charge. Now, it has been said and will be said that this is some partisan pursuit against the Biden administration, but really, it started before the Biden administration. There are instances of this, not quite as egregious, during the Bush administration. This is a wrong practice, no matter who the president is. And if the president is Republican in a year, then we'll be back in this committee, and I'll still be pushing this bill to be passed if we don't pass it before power changes. Because at the end of the day, Congress should be making the decisions about where this money goes, not unelected bureaucrats. And what this bill seeks to do is take away this practice that was stopped during the Trump administration. But frankly, we should have passed the bill during those last 2 years of the Trump administration. We should not have just said, okay, great, the problem's solved. Legislation should have been passed. It wasn't, and here we are. And yes, I am critical of the Biden administration, but frankly, there are multiple instances across party lines of malfeasance. And I yield back and thank the committee for their time.
Thank you very much. Ranking Member Nadler, you're recognized for your opening statement.
Thank you very much. Chairman Cole and Ranking Member McGovern, H.R. 788, the so-called Stop Settlement Slush Funds Act of 2023, would prevent the Justice Department from negotiating settlements to include payments to third parties, primarily nonprofits and community-based organizations that are best positioned to remedy harms to society at large that were caused by a corporate wrongdoer's violation of federal environmental, labor, consumer, and financial protections. This bill is nothing short of a gift to large corporations that would leave victims of their misconduct out in the cold. No credible facts justify H.R. 788. This bill is based on the false premise that the Justice Department uses these types of settlements as illegitimate favors for the administration's political allies, with the bill's supporters describing such settlements as politically motivated slush funds. This is an outlandish attack on a perfectly legal and constitutional type of remedy, and is an argument that both the Government Accountability Office and the Congressional Research Service have thoroughly debunked. Yet House Republicans have spent countless hours and taxpayer dollars over several Congresses, going back at least a decade, chasing the conspiracy theory that the Justice Department is attempting to fund liberal activist groups and causes through negotiated settlements. This included a multi-year investigation of the settlements that the Justice Department entered into with several big banks following the 2008 financial crisis. Banks whose greedy appetite for mortgage-based securities led to predatory lending practices that ultimately left millions of homeowners facing foreclosure. The big banks turned a blind eye to these practices. While they packaged mortgages that they knew were of questionable value as securities and sold them to individual and institutional investors alike. Although the big banks' illegal conduct led directly to the 2008 financial crisis, it was difficult, if not impossible, for individual borrowers or homeowners to hold them legally accountable for the harms they suffered from the bank's near implosion of the nation's financial system. In response, roughly 1% of the settlement monies in suits brought by the government ultimately went to third-party organizations specializing in aiding private homeowners to obtain mortgage relief or other community-related services, a perfectly reasonable way to help remedy the harm caused by these large financial institutions' irresponsible behavior. Unsurprisingly, the House Republican investigation into these settlements produced not one shred of credible evidence to support their allegations that this represented some sort of improper action, a common result when it comes to the majority's oversight priorities, it seems. Nonetheless, the majority seeks to enact H.R. 788, a bill that purports to address a problem that does not exist, while its proposed solution would create real negative consequences for the American people. Were Congress to pass H.R. 788, it would reward corporate lawbreakers and further victimize the families and communities suffering from the consequences of corporate misconduct, including injuries from civil rights violations, environmental justice harms, or harms caused by fraudulent lending practices. H.R. 788 is simply a tired attempt by the majority to paint the constitutional veneer upon their unpopular anti-regulatory agenda, which includes enacting legislation that will undermine critical financial, environmental, public health, and safety protections for the American public. This anti-regulatory bill is a solution in search of a problem, designed to serve deep-pocketed corporate interests at the American people's expense. It's a shame that House Republicans have chosen this unjustified and harmful bill as the first measure to bring to the floor in this new year. We could have started this new year by considering bipartisan legislation to address a real problem. At the same markup where the Judiciary Committee considered this bill, we also considered legislation that would have addressed bipartisan concerns about federal civil asset forfeiture laws. The bill passed the committee by a 26-0 vote in favor, and I have no doubt that it would have enjoyed strong bipartisan support on the floor. In addition, as we are once again at the precipice of a possible government shutdown, House Republicans have chosen instead to waste time on H.R. 788, recycling an unnecessary bill at a time when the House should be working expeditiously to ensure that the government stays open. In short, rather than considering ill-conceived and harmful legislation, we ought to be devoting this first legislative week of the new year focused on serving the actual needs of the American people, the basic job that we were elected to do. I thank the chairman and the ranking member and welcome any questions on H.R. 788 the committee may have.
Thank you very much. The chair will forego questions at this time. Yield to the distinguished gentleman from Pennsylvania for any questions he might have for the panel.
Thank you, Mr. Chairman. In taking your lead, I too am going to forego questions, and I yield back.
Now I recognize my very good friend, Mr. McGovern, for any questions he may have.
If I thought it would end the rain, I would ask questions. But rather, I think if I'm asking questions, I'm just unnecessarily prolonging this hearing. I thank both gentlemen for being here, and I yield back.
The young lady from Minnesota is recognized for any questions she may have.
Mr. Chair, is it okay if I ask a question?
Certainly is.
I feel like I'm breaking the...
No, that's all right.
No, I just wanted to ask Congressman Gooden if you could talk a little bit about the settlement funds and maybe how they are different from government funds, and that maybe we shouldn't be doing what we're doing with them, and how they're treated differently. And
Yeah, so a lot of these settlements, we don't know what the terms are. We just see the announcements. A bank or whoever the violator is, they make an announcement of this big gift to whoever they agree to give it to. There's also no oversight of those funds. If one of these organizations receives funds from the U.S. government, they have to be accountable for how those funds are spent. There's transparency. If they receive funds in a settlement, that does not exist. And so that's one of the main differences. The other thing I'll address too is this idea that there's no political cause for where these donations go. And I'll even pick on things that happened when Republicans are involved, just to show you that it is across the board. It's not really one side or the other. It just so happens that Democrats are in charge of the executive branch today. But back in 2005, a gentleman, you may know him, his name is Chris Christie. He was then the U.S. attorney, and he required a pharmaceutical company, Bristol Myers Squibb, to donate to his law school alma mater, Seton Hall University. In exchange for not charging the drug-making giant with securities fraud, his office would require it to fund a professorship at Seton Hall University's law school, which is his alma mater. The $5 million gift, one component of a larger agreement between the company and prosecutors, was hailed by the school as a cornerstone of its new Center on Business Ethics. Now, I'm thrilled that they got whatever Center for Business Ethics they got. But the fact that they got it because an attorney, U.S. attorney, ordered a company to send a check in exchange for getting off, that's wrong, whether that U.S. attorney is a Democrat or a Republican. And so this has continued. It's still happening now. It happened during the Bush administration. I got lots of instances. I'm picking on Republicans now because I feel like that everyone in opposition might enjoy one of those Republican examples. But it's really a bipartisan problem. And I'll also pledge to this committee that in the event that we have a Republican president in a year, I'll still be pushing for this legislation, because I would venture to guess that Democrats, if we have a Republican president, wouldn't enjoy settlements being shipped off to the Heritage Foundation or some of these other conservative groups, which, no matter the cause, it's wrong. Congress should be in charge of appropriating funds, and victims should be given restitution in the form of money directly to the victims, or businesses or whoever has committed the crime should pay a fine to the United States Treasury, so all of us in this room in Congress can determine how that money's spent, not some organization that gets these no-strings-attached dollars. And so I would argue that we should take back this power from the executive branch, no matter who runs the executive branch. And thank you for your question.
Thank you very much. I recognize my good friend from South Carolina for any questions he might have for the panel.
Thank you, Mr. Chairman. I'll be brief. Lance, thank you for bringing this up. It's unbelievable that, and I didn't realize this existed. And it looks like the abuses go back and forth between both parties. So am I understanding this right? The victims would not get the money. It'd be under the direction of unelected bureaucrats who took no part in building either of the companies that were viable.
Well, it depends on the situation. If it's an organization that directly deals with these types of victims, then perhaps they'll see something. But in some cases, we see, for example, the Biden administration directed settlements to fund the National Fish and Wildlife Foundation with one of the settlements, I believe, after the Volkswagen scandal. And so in some cases, perhaps victims have restitution, and in some cases they don't. The point is we as Congress should be able to know where the U.S. taxpayer dollars are going, which we can when we send taxpayer funds, but these aren't taxpayer funds, these are settlement funds. So it's slightly different in that sense. And I share your lack of knowledge, because before I got here, I did not know this was really an issue either. And I think one of the problems was that Trump stopped this practice, and when he stopped it, there was less of a push in Congress to actually codify it into law that we shouldn't keep moving forward, and that's where we messed up.
Well, I appreciate you bringing this before us. I yield back, Mr. Chairman.
Thank you very much. The chair now recognizes the gentlelady from Indiana for any questions she may have for the panel.
Thank you, Mr. Chairman. I just want to note one of the reasons why this legislation is important. Under the Obama administration, the federal government frequently negotiated settlement agreements requiring defendants to make payments to favored or politically friendly third parties that were not involved in the litigation, rather than directing payments to injured parties or depositing them into the U.S. Treasury. Because those payments don't flow through the U.S. Treasury, and they often involve non-disclosure agreements, there's really very little transparency, as some of our colleagues have noted. The administration sent a statement of administration policy claiming that the federal government does not create or use these slush funds in that manner. Representative Gooden, I know you touched on some of this already, but what is your response to the administration claiming that they do not create or use slush funds in this manner?
I mean, well, the facts speak otherwise, and I'll be a nice nonpartisan guest here and say that the Republican administrations before this one, before this Democrat administration, were also guilty of this practice. But one of the arguments I've heard today is that this would be a gift to corporations. The corporations are the ones getting the gifts here because they're not really having to pay up when they do something wrong. They're making a deal with the executive branch, with the DOJ. They're having to pay less. If the penalty would have normally been $10 million, they're only having to pay $5 million, and they're writing it off and giving it to an organization and getting to put out a press release that they're actually really great, et cetera. And so I think we just need to go back to the times of Congress determining where money goes and let the Justice Department serve justice. And whatever that penalty is, that goes into the Department of Treasury, and we as members of Congress provide oversight for how that money should be spent.
So how common is it that the federal government would utilize this practice of settlement slush funds?
Well, with respect to civil cases, I think it's pretty common. If you're a corporation, then this is a sweet deal, and so you're definitely pushing this, and this is something very advantageous as opposed to writing a check to the government. When you write a check to the Treasury as a fine, it looks like you've really done something bad. When you settle behind closed doors and then you come out and you write a big check to a charity, no matter what that is, you don't necessarily have to admit any wrongdoing.
And isn't paying it back to the Treasury a better way to not only enforce a penalty that is meaningful on some bad actors, but also to give back to taxpayers in general versus winners and losers that an unelected bureaucrat might pick and choose?
Yes. If there's victims that have been harmed, they should get the money and be made whole if that's possible. Otherwise, that money should be given back to the Treasury and members of Congress. The government, the Constitution says we have the power of the purse, and what this practice does is it basically gives the power of the purse in some way to the executive branch. And I would just advise everyone to kind of think about the future. Perhaps a Republican, if you're a Democrat, a Republican's in charge in the future. They're running the DOJ. And then you're starting to see settlement slush funds go to the NRA Foundation or to conservative groups that you as a Democrat may not really like. In which case, I suspect I might have someone across the aisle join me in carrying this legislation in the next Congress. But this should be bipartisan. It is a bipartisan problem. Unfortunately, the solution today is not bipartisan, but I hope someday it will be, and that we'll get this solved.
All right. Thank you, Mr. Chairman. I yield back.
The gentleman from Colorado.
Thank the chairman, and good evening to, of course, our ranking member and my colleague on the Judiciary Committee. Thank you both for your testimony. I would first just be remiss if I didn't echo the sentiments I think that were expressed by our ranking member, Mr. McGovern, which is obviously this is the first hearing that we've had in the Rules Committee since we recessed last year. Government funding runs out in 10 days, a partial government funding deadline. Of course, there's a second deadline 2 weeks after. Many agencies in our government, including the Department of Justice, would be impacted, the very agency that we're discussing today. And rather than taking up any appropriation bills here for the first hearing of 2024, we are debating a bill that looks to be a solution in search of a solution. And I was hopeful that 2024 might start off on a better foot, at least as far as the Rules Committee goes, than 2023, but unfortunately, that does not seem to be the case. Nonetheless, we proceed. With respect to the specific bill that's before us, and of course I know we had a robust debate about it during the Judiciary markup a few weeks back, or last month, I should say. Are you familiar, Mr. Gooden, with the CBO report that was issued on this bill?
Yes, I couldn't quote it, but I have it in front of me. If you'll give me a second,
Yeah,
or you can start talking.
Take your time, sure. Well, in a fairly basic question, my understanding of the CBO report, the language within the report makes clear their view that if this bill were to become law, there would be more litigation, not less, from the Department of Justice. Are you familiar with that?
You know, I've heard that argument, but their job is to carry out justice. And if in the process of doing that, they're going down this road, which I believe, and my colleagues seem to agree with me, that this practice is wrong, then that may be an adverse effect. But I'm not interested in moving things along quickly if it means not doing it the right way. And I realize we disagree on the concept here. My argument, though, is that we as members of Congress should be in charge of how this money is spent, and that, yes, we're talking about the Biden administration today, but earlier I was talking about the Bush administration because it's been a bipartisan practice to go down this route of these settlement slush funds that I'm trying to stop, no matter who's in power.
And I appreciate your view. And what I'm getting at here is it's clear that this bill will result in more litigation on the part of the Department of Justice. Therefore, that's going to require more appropriations for line attorneys, for the civil division, for the criminal division at the Department of Justice. That's certainly something I support.
Yeah.
We've struggled, and I'll give you a chance to respond, we've struggled to get, or rather earn, I suppose, the support of many of our colleagues in your party and in the majority in the chamber to support baseline appropriation levels for the Department of Justice, let alone increased levels for the Department of Justice. So I'm trying to reconcile this conflict, or dichotomy, I should say, between pursuing a bill that the CBO very clearly says will increase litigation and therefore will increase expenses, while simultaneously opposing increased appropriations to the agency that is going to be engaged in that litigation.
I would argue that this is not, to say it will increase litigation is to assume that we're taking away the settlement option. We're not taking away the government's.
That's not me saying it, it's the CBO saying it. I mean, it's in the document.
And I'm saying that you're making not you, but one has to make an assumption that the ability to settle is being taken away here. And perhaps they're misreading the bill or we're going down a different path. But we're not taking away the government's ability to settle with a wrongdoer. We're just saying, if you're going to settle with someone, with a company that has done wrong, then you're going to actually make victims whole, or you're going to write a check to the U.S. Treasury. We're just taking away this option of the executive branch of the DOJ saying you can write a check to XYZ charity.
But I guess I thought your argument a few moments ago with the gentlewoman from Indiana was that there were corporations that were getting off, and that this process could take longer because now a corporation, in your view, wouldn't be able to make a donation and then write that off for tax purposes and all the rest. I mean, you can't have it both ways, right? I mean, fundamentally, either you believe that the current process that the Department of Justice has implemented is such that it enables corporations to not have to engage in as much litigation as they would otherwise, or you don't believe that. And
You're the one that said the litigation part. I'm saying that,
Again, not me, the CBO.
that a corporation currently oftentimes goes down the path to where the government says, we're going to settle with you and we're going to sweeten the pot and allow you to write a check to XYZ charity, organization, cause, instead of writing a check to the U.S. Treasury. We're just taking that option away from the executive branch and saying, moving forward, no matter who's in power, no matter who's running the government at the executive level, we're taking away this option of unelected bureaucrats to be able to direct settlement funds to anywhere other than the U.S. Treasury or the actual victims.
And all I'm suggesting is that the CBO has stated that doing what you just described will in turn lead to more litigation because it's one less tool in the toolbox of the folks at the Department of Justice. And you can believe on the merits that that nonetheless is a price worth paying, which I suspect you do, and perhaps there are others. But that's my point here is only to just suggest, irrespective of the merits of this particular bill, I think too far often this committee, the broader House, has become accustomed to ignoring the warnings and the dictates and the statements issued by the CBO as we contextualize these bills. If you believe that this is a policy worth pursuing, then I would hope that you will be just as supportive 10 days from now, or I hope sooner, when we take up a Department of Justice appropriations bill, so that they have the appropriate revenue streams they need to be able to potentially engage in the extended protracted litigation that's likely to result from the bill. But Ranking Member, I'm happy to.
Thank you.
If you'd like to expound on any of this, otherwise I'll.
Well, I just wanted to say one, first of all, thank you. I just wanted to point out one thing. It seems to have been lost in some of the comments of some of the members here. In these cases, the Department of Justice or whatever government agency negotiates the settlement. The settlement entails a payment to the government, in addition to which, not instead of, in addition to which, as part of the settlement, a payment is made to an organization which it is judged can help to right the generalized wrong. So, for example, when the banks were selling, were securitizing mortgages they knew were unsound, and homeowners are left holding the bag, in addition to a settlement with a payment to the government, a payment was made to, I don't know what the name of the organization was, but to an organization that would help homeowners to deal with the consequences of the wrongdoing by the banks.
It's a very important point, Ranking Member Nadler, and I'm glad you made it. They're not mutually exclusive. Those payments, those terms of the settlement supplant the payments made both to the government and in other cases, there's direct restitution to victims. So in any event, I will yield back to balance my time.
Thank you, Mr. Neguse. And with that, we yield to my good friend from New Mexico.
Thank you so very much, and thank you, and welcome back to 2024. It's going to be a momentous year, and I share my colleagues' concerns that in this momentous year, we are beginning with a bill that is not as momentous as one would hope, because what it is indeed doing is, instead of solving the major issues that our communities want us to look at and to solve, including funding the government, we are basically taking away, with this bill, a tool that the federal government has to hold our biggest banks accountable, to hold those accountable who hurt the little guy, who hurt the little gal, who hurt the working families. And that's what is concerning here, is that we are going in the opposite direction of what our communities want us to do. And this has been a pattern that we've seen by the Republican majority. They showed us with their massive budget cuts, proposed budget cuts to the Consumer Product Safety Commission, and their efforts to weaken the Consumer Financial Protection Bureau. These are entities that Americans trust because they help our working families, right? And they wanted to cut them. They then wanted to have $45 million cut from the community development financial institutions. Once again, CDFIs. Who do CDFIs invest in? In the small businesses, in the communities that struggle, that the big banks ignore. Now we have a bill that would prevent settlements that help consumers get back on their feet after big banks do bad things. And we have examples of that, right? And I think that's what the ranking member was referring to, and as referred to earlier, the 2014, the Department of Justice and Bank of America reached a settlement agreement over the bank's faulty subprime mortgage practices in the lead up to the 2008 financial crisis, right? The big banks did bad. Now, Representative Gooden, I know you're concerned about this idea of a slush fund, but don't you agree that Bank of America's actions were harmful? I mean, do you agree that there were negative far-reaching impacts, not just on consumers, but on the economy? Yeah, that's really a yes/no question. Do you think what Bank of America didn't back then was wrong?
Yeah, and they really got off pretty easy. And what you're saying is you want banks and bad actors to keep getting a sweet deal from the government. Because they didn't have to write a check to those who were wronged. They made a sweet deal. They wrote a big check to all these organizations and said how great they were. They didn't really pay a price. And so this argument that I'm hearing from my colleagues across the aisle that this is some gift to corporations, no, we're trying to take away the gift that the corporations have. You all are advocating to keep things as is, and that's a gift to these bad actors, because these bad actors are getting off. And I want to apologize to my colleague from Colorado. I didn't have this CBO report in front of me, but it's not really explosive. I'm reading it, and it says, based on conversations with officials from the DOJ, CBO expects that by precluding such donations and civil settlements, the enactment of this bill would likely reduce the number of civil settlements. I mean, such settlements are typically recorded as revenues to the government. The thing is that, and it didn't come to me while you were talking, you take away the settlements problem, this issue, and you make them write a check to the Treasury, well, then you got more money. You were talking just a second ago about, I hope you'll fund the DOJ. Everyone wants to fund the DOJ, mostly, but you take away this option, and these bad actors are then writing checks to the Treasury for everyone in this room to decide how it gets appropriated. But with respect, what you're arguing for is that Bank of America or JP Morgan Chase, in the case of this Epstein scandal, they're all getting off because of this practice. We Republicans are trying to take this off the table so that these bad actors have to write a check to the government and say, hey, we're guilty. We're not some good guy.
Yeah.
We're guilty. Make them say we're guilty. You all are keeping this tool in place to where they don't have to admit guilt. They quietly make a settlement, and then they just write some checks and put out a press release. That's not justice.
No, I think justice is really looking at what are the greater harms that these big banks have done and saying, and we are going to use multiple tools in order to make it better. And I think when we start limiting the way in which we can solve the problems to say the only tool is a check to the Treasury, is simply limiting ourselves. And instead, what we tried to do with the Bank of America settlement is we actually did look for what are some of the tax relief payments that could be had. What are ways in which the Neighbor Works America can work to increase funding for mortgages? So there are many different ways in which you could use these settlements to address the harm that we were facing. And Ranking Member Nadler, isn't this one of the things that we want, is that we want our Department of Justice to have the broad range of tools to hold big banks accountable and say, this is the way you hurt our people, this is the way you hurt our community, and we are going to make you pay. Because that is a payment. It is not letting people off. It is holding them accountable. Wouldn't you say, Ranking Member?
I totally agree, obviously. Now, what is happening in these cases, what happens in a case like the big banks, a settlement is reached. A settlement is reached and a payment is made to the government, and a payment is made to an organization that will help the victims of the bank, in this case, actions. Now, if you say there shouldn't be a settlement, then you're saying every case must be litigated?
No one said that.
Well, then you certainly want, in addition to the settlement and money going to the government, you want money going to somebody who's going to help the victims. And that's what this is. And this bill would take away that ability to, as part of the settlement, give funds to an organization to help the victims. So, for example, if there's an environmental catastrophe, some big company is leaking some toxic chemical into the water table. Well, government negotiates a settlement, but then you want to give money to some organization which is going to help the victims with the resulting damages. And that's what this bill would prohibit.
Right, and I think that's the key, is that there are many different ways of solving a problem, and you need to involve everybody who can help. And what this bill wants to do is cut the source of funding off of those organizations that can help. And I think Americans understand. We live in our communities. We participate with these organizations. We benefit from them. And I think we need to go back to realizing that the world is not made up of big corporations and government, and that's it. No, the world is made up of communities, and those communities have within them wonderful community organizations that are doing great work that then can help solve these problems. And so that's why, I would urge my colleagues to oppose this bill, urge my colleagues to think about who are you standing up for? Are you putting sort of politics, above people? Are you putting the big players, the big corporations, above the people that need the help and above the communities that are going to help them get that work done? And with that, I am going to yield to my colleague to address some of the issues around the CBO score.
Well, I just would, I thank the gentlewoman for yielding. I certainly agree with her sentiments. I think the CBO score, again, and the statements that are included in that document speak for themselves and clearly foresee an increase in litigation. But putting that to the side, I would just simply say, in response, sir, to some of your comments, it is rich to claim that this bill is somehow targeting corporate actors when there are a bevy of corporations and corporate trade associations that support the bill. Virtually every consumer organization that I can find opposes your bill. The Chamber of Commerce and a litany of other business organizations support it. So the American people understand. Again, you can make an argument about the separation of powers, and I think there have been arguments made with respect to the ability for the executive branch to appropriate funds and the unique and nuanced issues that arise thereof that are presented by your bill. But to somehow state that this bill is being done in the interest of the consumer and not of the corporate lobby, I think it is bellied by the facts. So with that, I would yield back to the gentleman.
Well, thank you. And I think that also raises, like, using the Bank of America case, there was $7 billion, that went to consumers, as I understand it, and only $487.3 million went to third parties. So you saw that consumers who were directly harmed received benefit, and then there was this additional assistance so that we could address the problem, the systematic problem that, in that instance, Bank of America had helped cause. And with that, I yield back. Thank you, Mr. Chairman.
Thank you, I appreciate it. Would any of the witnesses like to have some closing remarks? Ranking Member Nadler?
I think the issues have been sufficiently addressed.
Fair enough. Mr. Gooden?
I agree with Ranking Member Nadler.
Well, I have to say, Mr. Nadler is in here all the time. He's a seasoned pro, a true veteran. Mr. Gooden, this is your first time in here. Handled yourself really well, both witnesses.
Mr. Nadler coached me up a little bit in Judiciary.
Has he been mentoring you on coming up here? Well, hey, thanks for coming in. Really appreciate it.
Thank you.
Thank you, Mr. Chairman. Thanks.
Thank you. Thank you.
How are you, Ralph?
He's such a nice young man.
He's great.
That's how your mom.
All right, I'd like to welcome our second panel, Chairwoman Virginia Fox and Representatives.
Hello, what a pretty sweater. Thank you, thank you.
All right, I'd like to welcome our second panel, Chairwoman Fox and Representative Susan Wild from the Committee on Education and Workforce. And Chairman Fox, I'd welcome your testimony.
Thank you, Mr. Chairman, and thanks to members of the committee for being here. Under the Biden administration, the NLRB has developed a nasty little habit of issuing partisan edicts that hurt hardworking families and small businesses in every zip code across the nation. It appears the only thing this agency knows how to do is press its thumb down upon the very people whom it purports to serve. The NLRB's new joint employer rule is yet another radical edict It's a clear example of bureaucratic encroachment. Under this rule, an employer now includes those who have only indirect or even potential control over employees' essential terms in conditions of employment. Small businesses would be pulverized, jobs would be wiped clear off the map, and the economy would be punched squarely in the jaw. HJ Res 98 offers us the opportunity to stamp out the NLRB's asinine rule that's anti-freedom, anti-business, and anti-growth. What's more, HJ Res 98 will prevent future anti-enterprise administrations from implementing a similar job-killing joint employer regulation. We often speak about the value of the American dream, how people can get to such a point where they can own and operate their own business. But what is seldom discussed is how the federal government grants itself the latitude to infringe upon the American dream, like what we see in the NLRB's new joint employer rule. We should be advocating policies that empower America's entrepreneurs and workers to succeed, not policies that greenlight more government control. With that, I urge the committee to report a rule including HJ Res 98 and yield back.
Thank you, Chairwoman Fox. The gentlelady from Pennsylvania.
Thank you, Mr. Chairman. Good afternoon, Chairman, Ranking Member McGovern, and members of the Rules Committee. I'm here today to speak in opposition to HJ Res 98, a Congressional Review Act resolution to repeal the National Labor Relations Board's 2023 Joint Employer Rule, which, it's worth mentioning, is an effort to correct a Trump-era narrowing of the long-standing NLRB rules on joint employers as set forth in the Browning-Ferris case. Millions of Americans have jobs through subcontracts or temp agencies, including janitors, housekeepers, cooks, and many others. And in fact, we are seeing more and more of that as employers endeavor to outsource their workforce. And these people work on behalf of a company that directs their work but does not sign their paycheck. These arrangements will weaken workers' ability to organize and collectively bargain or otherwise hold their employer accountable. For example, let's say employees of a subcontractor were to unionize with that subcontractor, but the subcontractor may well simply refuse to bargain over pay, hours, workplace safety, or other issues because its contract with the prime contractor governs those aspects of the work, which means that workers' desired improvements at their workplace are out of reach because the entity that controls their workplace policy is not at the bargaining table. The NLRB's 2023 Joint Employer Rule fixes this problem, and it ensures that millions of workers can hold all entities that actually control their working conditions accountable for their right to collectively bargain for higher pay, better benefits, and safer workplaces. This is essential to our promise to support workers and their families. Unfortunately, by repealing the NLRB rule, HJ Res 98 would undermine workers' ability to exercise their rights and would reinstate the deficient Trump-era rule that narrowed the joint employer standard and would render the whole bargaining process useless. In fact, the Trump-era rule transferred $1.3 billion each year from workers' paychecks to their bosses' pockets, whereas the NLRB rule would increase worker earnings by over $1 billion annually collectively. Repealing the NLRB rule would also steer us further away from the purpose of the National Labor Relations Act and years of court precedent. The Supreme Court has long affirmed that workers must be able to bargain with an employer to the extent that it controls their pay, their benefits, and other basic terms of employment. The D.C. Circuit reaffirmed this in 2018, but the NLRB's prior Republican majority failed to follow the court's decision in its Trump-era rule. Finally, I want to address much of what has been said about the NLRB rule and the franchising relationship. As somebody who supports franchising and small business owners in my district and across Pennsylvania, and in fact have had family involved in a franchise business, I want to set the record straight. There is no credible evidence that the NLRB's joint employer rule threatens the franchise business model. In March, a franchise owner testified before the Education and Workforce Committee. My colleague, Representative Bonamici of Oregon, asked him if the franchisor controlled the hiring and firing of his employees, if the franchisor set his employees' wages, and if the franchisor set his employees' schedules. In each case, the franchisee owner said no. If franchisors do not control these working conditions, the joint employer standard does not affect them. In fact, a strong joint employer standard protects franchisees because it makes sure that the franchisor cannot control the standards under which their workers are working, but then leave them, the franchisees, on the hook for any liability. The NLRB has never found a franchisor to be a joint employer of its franchisees' employees. There is no reason to believe that it will do so in the future if the franchisor's control is limited to the brand, which is typically the model that one sees in a franchise relationship, and as long as they do not extend their control into the franchisee's labor relations. Instead of advancing HJ Res 98, we should be working to pass HR 20, the Protecting the Right to Organize Act, the PRO Act, which strengthens workers' ability to organize and collectively bargain. In Pennsylvania and across the country, we have seen a surge in labor organizing and sky-high popularity for labor unions. The House should be leaning into that and supporting workers' efforts to join together for higher pay, better benefits, and safer workplaces. This resolution would do the opposite, and it should be opposed. I appreciate the opportunity to be here with you all, and I welcome any questions.
Well, thank you. I'm going to forego questions just to move things along, so I yield to my friend from Minnesota. Ranking member?
Thank you. I want to thank the witnesses for being here. I just want to ask unanimous consent to insert into the record the Statement of Administration Policy, which says quite explicitly, if the president were presented with HJ Res 98, he would veto it. So this bill isn't going anywhere. Again, I would repeat what I said at the beginning of this hearing and what Mr. Neguse has also said. I mean, you know, we are coming up against some really harsh deadlines. One of the primary jobs of Congress is to keep the lights running. And it doesn't seem that there's much urgency amongst House Republicans to do that. I would urge my friends on the other side of the aisle to get serious about averting first a partial government shutdown, and then what may be a total government shutdown, and not be doing this kind of stuff. With that, I yield back.
Thanks. Without objection, we'll enter it into the record, and I yield to my good friend from South Carolina.
Well, that is one of the issues. That's one of the issues, because what the NLRB wants to do is to say that the parent company, like McDonald's, for example, really does control what's happening with these employees at local franchisees. And so they are indirect employers of those people, and they want to be able to go after the sort of parent company where the big bucks are, not where the local franchisee is. And that's one of the big issues involved here.
It's up to their determination.
That's right.
That's a huge problem.
Yes, sir.
Okay, thank you. Appreciate you bringing this up.
All right, thank you. My good friend from Colorado.
I thank the chairman and thank the witnesses and have no questions.
The gentlelady from New Mexico.
Thank you so very much, and thank you, Chairwoman, and thank you, Representative. So I would like to enter into the record, Mr. Chairman, I request unanimous consent to enter into the record a letter of opposition to Republicans' attempts to overturn the Department of Labor's joint employer rule. The letter is co-signed by 72 labor and workers' rights organizations representing tens of millions of American workers.
Without objection.
Thank you very much. And I think what this letter signifies, as it writes down, and what we heard from Representative Wright, is the fact that it is so important to make sure that workers are able to enforce their rights, that they're able to unionize, that they're able to protect their rights, regardless of whatever shell games may be played by contractors. And so with that, I will yield back unless there is anything that you would like to add to this, Representative Wild.
I'd like to just comment on the question asked by Representative Norman. I think it's very important to note that the joint employer rule requires that the two employers share or co-determine one or more of the employee's essential terms and conditions of employment. So this is not a situation where a McDonald's, for instance, franchise, has to necessarily be considered a joint employer, the franchisor and the franchisee, because if the franchisee makes the determination that certain employees are going to work certain hours, that they're going to, remember the franchise relationship, which is where most of the criticism usually comes from, is modeled on the idea that the successful franchisor brand is followed through in the franchisee's place of business. So they want to make sure that it looks like all of the other franchises. They want to make sure that it's kept clean and orderly and that the quality of the food, if that's involved, is standard. They are not going to be getting involved in things like what hours you determine employee X or employee Y may work. You would not be a joint employer in that situation. And so I think that it's a myth to think that all of a sudden we're going to see nothing but joint employers everywhere. Because the small business owner, in this case a franchisee, which is a small business most of the time, although some franchisees own hundreds of franchises, is still able to control the essential conditions of his or her workers' employment.
Can I ask you a question?
Sure. I'll yield.
Oh, okay, I'm sorry.
Always to you, sir.
What the franchisees do, they have the franchisor set the bar for, like a Lowe's, a standard building. They have a brand that they're selling. And they don't set hours, as you mentioned, but now they do set the recipes, they set give you a list of equipment that they have, buying power. But now the problem is, who determines that?
Well, that is determined by the franchisor-franchisee
I get
agreement.
that. I'm talking about who determines that from when Obama put this in. Who decides what's indirectly that would link them as being joint employers?
I'm not sure I understand your question, but the things that you just mentioned would not be considered terms of employment. They wouldn't be part of the employee's working conditions. Those would be part of the entire franchise relationship where the franchisor wants the franchisee to carry forward the brand. That does not impact the individual working conditions of the workers.
But beauty's in the eyes of the beholder, isn't it?
I'm not sure I understand that question. I'm not sure I understand that comment, but I'm happy to tell you what the essential terms and conditions of employment would be, how they're defined. They're defined as wages, benefits, and other compensation, hours of work and scheduling, the assignment of duties to be performed, the supervision of the performance of duties, work rules and directions governing the manner, means, and methods of the performance of duties and the grounds for discipline, the tenure of employment, including hire and discharge, and working conditions related to the safety and health of employees. So this franchise model, Lowe's, McDonald's, whatever you want, that is not that does not encompass these items. It's only when that employer, let's say the franchisor, got involved in dictating what the wages would be for the employees, which is not going to happen because the franchisee wants to make money by having this franchise, right? So he or she is going to determine wages and schedules and that kind of thing based on what is profitable for that particular franchise operation. That's not what the franchisor is interested in. The franchisor wants to make sure that the brand is carried forward. And so none of these items, and I'm happy to read them again if necessary, but none of these would be implicated in that franchise relationship. In fact, where you more often will see this kind of essential terms and conditions dictated is when employers, let's stay out of the franchise relationship for the moment, are simply outsourcing the work to be done, to whether it's to a cleaning service for an office building. You go hire the XYZ cleaning company, but they hire workers to go clean that office. They dictate what time they show up, how much they're getting paid, that kind of thing. That would be a joint employer situation.
The only thing I would add is the franchise, you're right, each franchisee runs different hours for the employees. They have different volumes. Not all stores do the same volume, but you've got to prove this. You know, just what you said, that you've got to prove that it's not joint employees. And that's hard to do when you have, I've seen stores get in trouble. This is what we do.
Well, I'm sorry.
Stores get in trouble, you call on the franchisees because they pay the fees. The franchisees want the fee, franchisors want the fees. But to have to defend this and define what indirectly means is a tough order.
Well, let me, if I may, in responding to that, these type of labor standards have been applied to businesses back to the 1940s. This is not something new and different that the NLRB has done. And I would respond by saying that these very specific criteria that I just read, which are part of the rule, actually would assist an employer in defending such a case. If, in fact, they have no control over any of these 7 items, they're not a joint employer. And it actually provides much more specific criteria that could aid the employer in defending such a case.
It's not that simple. I mean, it really isn't. It's where franchisees and franchisors come together to try to make a successful store, to prove that exact things you just mentioned. It's not that simple, and it blends in with trying to get a store that is not profitable and trying to make sure that the brand is set, and to leave it up to them for the interpretation of independently. I think that's what drives them crazy.
Nothing is ever completely simple, Mr. Norman, but let me just say that the point of this is to make sure that the worker is not the one caught in the middle and not able to actually negotiate the terms of his or her own employment. And I think that's really important to working folks.
You know what stops that? You know what prevents that? Competition. They're battling for, the employees have got the control, because they can go to a Chick-fil-A, they can go to a Home Depot, you name it. That's the lever that the employees have. And it's huge, particularly now. It's slowing down some. But thank you for your explanation, and it sounds like a thank you for yielding.
But of course. And I think that this discussion really reflects what we have seen in the last year or so, where we have had increased unionization at franchise stores. And those are occurring on a store-by-store basis because of the fact that they are independent, right? And it is the fact that there is now more competition from labor does not mean that we need to leave these workers alone. We need to make sure that those workers, if they choose to unionize, and if they choose to have representation, are able to do that. And is that sort of what we are looking at getting to here, Representative Wild?
In part, yes.
Yeah. And so I think that remembering that this rule was carefully crafted not to interfere with the ability of the franchisees to have and set their own terms of relationship between employee and employer. I think that that's the key say. It's like, what kind of working conditions do you have with your employees? It's that simple. I mean, their terms are there, you've repeated it, and that is why this rule was written in this way. And unless you want to add anything else, Ms. Wild? I saw you open your book back up again.
I just want to emphasize that this shouldn't just be construed in the context of franchises. That's not what this joint employer rule is solely about. In fact, if anything, it's about many, many other areas of outsourcing that don't affect franchises.
Right, and that in fact, we're going back to in history, I mean, NLRB was set up in 1935. These kinds of procedures were in effect for decades and for years until we saw what happened in 2020 during the Trump administration, and we are simply trying to right that wrong and stand with workers once again. With that, I yield back. Thank you very much.
Thank you, I appreciate it. Would the witnesses like to have any closing remarks? Ms. Wild?
No, thank you.
Chairman Fox?
Thank you, Mr. Chairman. I would just say, if it ain't broke, we don't need to fix it. Things are working very well without this joint employer rule. And the other thing I would think I will point out is this really is an attempt to make it easier for unions to unionize. And I think that's what just came out in these final remarks. Thank you, Mr. Chairman. I yield back.
Well, thanks for all the exchanges, and with that, the witnesses are excused. Thanks for coming.
Thank you.
The pins tomorrow.
It was fine, and these comes on the road.
Thank you.
Right, that's what I was thinking. We're fixing what's bigger.
Right, exactly.
Doing all right? Thank you.
I need you around a while. Slow down.
All right, I'd like to welcome our third panel today, Representative Troy Nels and Representative Jake Auchincloss from the Committee on Transportation and Infrastructure. Representative Nels, when you're ready, we can take your testimony.
I am. All right, thank you, Chairman Cole, Ranking Member McGovern, members of this committee. Senate Joint Resolution 38 was introduced by Senator Rubio in Florida under the Congressional Review Act and reinforces the importance of American manufacturing. This joint resolution of disapproval would invalidate the Federal Highway Administration's final rule, which provides a waiver of Buy America requirements for EV or EV chargers. In November of 2021, the Infrastructure Investment and Jobs Act, IJA, created the National Electric Vehicle Infrastructure Formula Program and the Charging Infrastructure Discretionary Grant Program, which were funded at $5 billion and $2.5 billion, respectively. Even prior to IJA's passage, President Biden set a lofty goal of installing 500,000 EV chargers by 2030, 500,000 of these things by 2030, and to support this heedless push for a massive transition to EVs, the Biden administration quickly moved for a Federal Highway Administration Buy American waiver for EV charging infrastructure. Yet the administration's broader implementation of the Buy America provisions included in IJA, they were slow, confusing, contradictory, as stakeholders continued to raise concerns regarding the lack of clarity and certainty. The administration has made it clear that it is willing to waive Buy America requirements when convenient to push its progressive policy agenda, even if it's not in the best for what Americans or our national and energy security. According to the White House, as of early 2023, there are approximately 130,000 public chargers in the United States. Meanwhile, China is leading the world in the build-out of these EV charger network, reportedly constructing 650,000 EV chargers in 2022 alone. However, an estimated 15 companies have opened or committed to opening or expanding EV charger manufacturing facilities right here in the United States. A Buy America waiver for EV chargers undermines undermines these important investments and risks empowering foreign adversaries like China. I have significant concerns with this broader push to EVs. That said, if the Biden administration is going to push their EV agenda on the American people, we cannot allow $7.5 billion with a B of our taxpayer funds to support Chinese companies. Congress should be focused on policies that put America first. For me, that means manufacturing items here and ensuring our labor, security, and safety standards are met. I cannot support merely waiving Buy America requirements simply because it's convenient for one woke agenda while turning a blind eye to the far-reaching ramifications it will have. I urge the Rules Committee to grant the closed rule. That I yield back.
Thanks, Mr. Auchincloss.
Mr. Chairman, Mr. Ranking Member, members of the committee, good evening. I oppose this resolution. The Biden administration has made deployment of electrical vehicle chargers a key provision of its climate agenda, and this resolution would create market uncertainty for the private sector at a time when they are actively investing in American manufacturing jobs. Strengthening the U.S. industrial base is critical, but this resolution would do nothing to achieve this and would actually undermine the work of the Biden administration to invest in American manufacturing and jobs. To achieve our climate goals, deploying EV chargers at scale is important to achieve the network effects necessary to make EVs a more attractive and practical option for consumers. This resolution will put the industry back at square one and delay our clean energy transition and allow competitors like the Chinese Communist Party to fill markets and constrain our ability to compete globally. The bipartisan infrastructure law included new domestic content requirements for all federal infrastructure spending, and the federal highway and transit programs have had Buy America standards for decades. These standards have ensured that any investment in U.S. infrastructure is also an investment in U.S. workers. So to understand the resolution we are debating today, we need to start with a quick history lesson. Since 1983, all manufactured products have been exempt from Buy America under the highway programs. That was a Reagan-era policy. Under this policy, EV chargers funded by the Federal Highway Administration would not have been required to be built in the United States. Further, there would have been no requirements for those chargers to include any domestic content beyond the iron and steel components. So if this policy then had been applied to the $7.5 billion laid out for the EV charging under the BIL, this funding would not have been invested in U.S. workers in the U.S. industrial base. The Biden administration took action to make sure that would not happen. In effect, they did a waiver on a waiver. First, it deemed that the general manufactured products waiver would no longer apply to EV chargers. It then created a new, stronger standard to replace it. A new, stronger standard to replace it. Under the new policy, and for the first time, all federally funded EV chargers must be manufactured in the United States. This new policy also includes domestic content requirements for all components, not just those made of iron and steel, as was previously the case. The domestic content requirements ramp up over several years to allow manufacturers the necessary time to expand their capacity in the United States. And it's working. This policy is working. Since 2021, private companies have announced $500 million in investments across the country in EV charging manufacturing facilities. And that's how Buy America is supposed to work, with the government as a customer. You can't flip a switch overnight on a 40-year-old policy. You need to give the private sector time to adjust. That's what the president is doing, and the resolution before us today would send the wrong signal to the private sector and would jeopardize the investments made in the EV charging industry. Beginning on July 1st of this year, all federally funded electric vehicle chargers will be assembled in the United States and will have at least 55% U.S. content, consistent with the Build America, Buy America policy included in the bipartisan infrastructure law. So just to be incredibly clear, what the Biden administration is doing is strengthening Buy America. It's a waiver on a waiver. This approach is a win for U.S. workers, the private sector, and all Americans who will benefit from a more sustainable transportation system. And it's technically called a waiver, but it's actually far more narrowly tailored and a much stronger Buy America policy than the broad waiver it replaces. I wish we had a different term than a waiver. We should call it like a counter waiver or something, because it's not actually what's happening right now. The resolution before us today would erase that progress. If we repeal the new Biden administration approach, electric vehicle chargers would once again fall under the broad general manufactured products exemption. We would create uncertainty for the private sector, who have based their investments in job creation on the new Buy America standards. We would jeopardize the investments already made in this industry, which again relies on critical mass and network effects, and which supports the U.S. industrial base and American jobs. We would undermine our climate goals by delaying the deployment of EV chargers and slowing consumer adoptions of EVs. Some may argue that the Biden administration could just repeal the 40-year-old general manufactured products waiver, the Reagan-era exemption for all manufactured goods. And the administration is in the process of reconsidering that waiver as required under the bipartisan infrastructure law. But it's a complex process to reconsider 40-year-old policy that applies to hundreds of products, ranging from traffic signals to the orange safety barrels we see at work sites. That process is going to take time to get right and should not be used as a rationale for weakening Buy America standards right now that exist today and that are working today. This resolution, again, would weaken Buy America, maybe for a period of months, maybe for a period of years, in the middle of a 5-year span during which we are making record investments in electric vehicle chargers. It would lead to incoherent industrial policy and slow down critical investments. And it's not just my opinion. This resolution is opposed by the women and men of the U.S. Steelworkers, the AFL-CIO, the International Brotherhood of Electrical Workers, those whose jobs will actually be affected by this policy. It's also opposed by the Zero Emission Transportation Association, the National Electrical Manufacturers Association, and Electrify America, whose members include EV charger and component manufacturers. We know, in conclusion, that infrastructure investments have the potential to invest in U.S. workers and American manufacturing, and the Biden administration's approach to EV charger investments delivers on that promise by strengthening the Buy America provisions relative to their 40-year-old standard under Reagan. Given that, I urge my colleagues to reject this resolution.
Thank the witnesses for their testimony. I apologize that I missed most of it. I was at another meeting, and for that reason, I'll forego my questions and turn to my good friend from Pennsylvania for any questions he might have for the panel.
Well, thank you, Mr. Chairman. I was here. The testimony was absolutely riveting. But for the sake of time, I'm going to go ahead and yield back.
Thank you very much. Recognize my very good friend from Massachusetts for any questions he may have.
Well, I thank both the witnesses for being here. Mr. Auchincloss, I think you made a very compelling argument as to why this is not something we should support. But the good news is it's going nowhere. The good news is that the administration has already issued a veto threat, and that this really is just filler to try to cover up for the fact that we are yet again on the precipice of potentially shutting down the government. Which is really inexcusable. I mean, that's one of the primary jobs that we have is to keep the lights on here, and you never know it from listening to my Republican friends, and especially this leadership fight with each other. But in any event, we're going to move forward. We'll have this debate, and again, it will go nowhere, and my hope is that my friends on the other side are working to try to make sure that we don't shut the government down, and basically hurt our economy. Although I heard Trump on the news basically saying hopes that there's a meltdown because it helps him in the next election. That tells you where his allegiance and loyalty lie. With that, I yield back.
Gentlelady from Minnesota is recognized for any questions she may have.
And, Mr. Chair, I will just say thank you for being here, and I support the legislation, I support the resolution, and with that, I yield back.
Thank you very much. Gentlelady from New Mexico is recognized for any questions she may have.
Thank you, Mr. Chairman, and thank you very much for the presentation, and thank you very much for the history about why we are here in this moment, and the fact that what we are looking at, what the Biden administration has been doing, is actually fixing some of the broad waivers that the Reagan administration gave, so that we weren't manufacturing what we need in America. And I would point out that the total value of U.S. manufacturing output in general, not just in this area, but in general, has increased by $1.3 trillion between the first quarter of 2021 and the third quarter of 2023. We are seeing that the last Congress, our policies and the Biden administration policies have really increased manufacturing in the United States. And it is this kind of policies where you're taking targeted action to start increasing rather than like wiping everything away, which is what this legislation would do. This is how you get it done. And so thank you very much for that history, and thank you very much for your passionate. I loved it when you got excited about how much EV transmission generation we were doing here in the United States. And with that, Mr. Chairman, I yield back.
Thank you, gentlelady. Gentleman from South Carolina is recognized for any questions he may have.
No, I just, Troy, thank you for coming here. Two things. One, it doesn't surprise me the Biden administration is waiving the Buy America products. He's tied to China. Look at where his payments came from. Secondly, talk to any car dealer, Williams, that people are not going to buy electric vehicles. They're not going to let the government force them to do it. And this is a complete boondoggle. And
You know what I find interesting? With this waiver notice, the Biden administration argues the waiver is necessary to achieve its, quote, bold vision to reshape the United States transportation system and support a sustainable energy and climate future. But yet, we all know, China is the world's #1 emitter of carbon dioxide in the world, producing 12.7 billion metric tons annually, over double the United States. Given that, I'm confused how allowing us to buy from China, who had their highest temperature of record this past summer, highest, and its hottest year on record, how that will help address global climate concerns and move the needle emissions. This is absolutely ridiculous. These EVs are being thrown down our throat. The American people are rejecting them, and it's not good for this country. Buy America, BABA. Buy America, build American.
I'll give you two examples. 2 cars blew up. The batteries completely
Yeah.
blew up in South Carolina, hurting 2 children. It's insanity. That's what they're doing. Did you have a comment, Congressman?
Yes, thank you. First of all, I will say on a positive note, it's quite refreshing to hear my Republican colleagues care about the climate and temperature in China. It's a progress for us that we are taking seriously the threat of climate change and what it's going to do for the planet that we're leaving our children. But I do need to reject the premise here that this is a waiver that loosens standards for Buy America. I tried to really delineate quite clearly in my remarks why that's in fact the opposite of the case. There is an existing waiver right now, passed under Reagan, that broadly, for all manufactured goods, provides an exemption, including the electric vehicle chargers. This is a waiver on that waiver. So it's really a counter waiver, and it actually tightens the standards. It requires that they be assembled in the United States, which was not previously the case, and in addition to iron and steel, which have always been Buy America protected, it requires that at least 55% of the components of the electric vehicle chargers themselves are now domestic content over the course of the next several years. This is strengthening Buy America. And in fact, this resolution that's being proposed right now, this would help the Chinese Communist Party, because by loosening it, it would allow their state-subsidized manufacturers to flood the U.S. market. So I would encourage those who are concerned either about the climate or about China, or ideally both, to reject this, because this is both a climate-conscious, pro-clean energy opposition here, but also one that supports American manufacturing and jobs.
May I ask a question regarding so I don't know what China was like with the United States in 1983, but I think they're a little bit bigger of a threat they are today, 40 years later than 1983. But why didn't the administration just go and address this 1983 rule, this law here? Just address it, address that instead of carving out the EV from this.
But so as I said in my remarks, the administration is, as required by the bipartisan infrastructure law, actually reviewing that Reagan-era waiver. That is a waiver that covers everything from traffic cones to electric vehicle chargers. They're doing it methodically, they're doing it surgically, and they're going to do it with Congress's consultation, as they should. But that assertion actually suggests that your advocacy for this resolution is misplaced. If you think the administration should be getting rid of that entire Reagan-era waiver, then you certainly shouldn't want to pass this resolution, which would weaken it.
I find it interesting that it passed the Senate. You had Manchin, Tester, Brown. I mean, they supported this. They supported this resolution, so.
Another way to say that is that.
And actually, the Senate is controlled by the Democrats, so.
Well, another way to say it is 90% of Democrats didn't support it.
No. It passed, and it's going to pass here, too.
Gentlelady from Indiana is recognized for any questions she might have for the panel.
Thank you, Mr. Chairman. I don't have any questions. I just want to thank Representative Nels for bringing the bill forward, and I agree with you. The waiver does nothing but make a bad decision worse. This administration is wasting taxpayer dollars on EV chargers that most Americans don't want and won't use. It's now pushing to line the pockets of the CCP, the Chinese Communist Party, instead of directing those taxpayer dollars toward U.S. manufacturers. It's not only wasteful, it's a handout to the CCP and Xi Jinping. So thank you for bringing this important legislation. I'm glad to support it, and I yield back.
Thank you very much. I want to thank both of our witnesses for appearing today, and you are excused.
Troy, you deserve a cigar after that.
Is there anyone else seeking to testify on H.R. 788, H.J. Res. 98, or Senate J. Res. 38? Okay, seeing none, or hearing none, this closes the hearing portion. Chair will be in receipt of a motion from the gentlelady from Indiana.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee grant H.R. 788, the Stop Settlement Slush Funds Act of 2023, a structured rule. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 118-18 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their respective designees. The rule makes in order only the amendment printed in the Rules Committee report accompanying the resolution. Each amendment shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in the Rules Committee report. The rule provides 1 motion to recommit. The rule further provides for consideration of H.J. Res. 98, providing for congressional disapproval under Chapter 8 of Title V, United States Code of the rules submitted by the National Labor Relations Board relating to, quote, standard for determining joint employer status, end quote, under a closed rule. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and the Workforce or their respective designees. The rule provides 1 motion to recommit. The rule further provides for consideration of S.J. Res. 38, providing for congressional disapproval under Chapter 8 of Title V, United States Code of the rules submitted by the Federal Highway Administration relating to, quote, waiver of Buy America requirements for electric vehicle chargers, end quote, under a closed rule. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Transportation and Infrastructure or their respective designees. Finally, the rule provides 1 motion to recommit.
Thank you very much. You've now heard the motions. Is there any discussion or amendment to the rule? Hearing no requests for further amendments, the question is on the motion to report. All those in favor signify by saying aye. Aye. Those opposed say no.
No.
The opinion of the chair, the ayes have it.
Mr. Chairman, I ask for a roll call vote?
Questions agreed to, but of course you may. Roll call's been requested. The clerk will call the roll.
Mr. Burgess. Mr. Reschenthaler. Mr. Reschenthaler, aye. Mrs. Fishbach. Mrs. Fishbach, aye. Mr. Massey. Mr. Norman. Mr. Norman, aye. Mr. Roy. Mrs. Houchin. Aye. Mrs. Houchin, aye. Mr. Langworthy. Aye. Mr. Langworthy, aye. Mr. McGovern.
No.
Mr. McGovern, no. Ms. Scanlon. Mr. Neguse. Ms. Ledger Fernandez. No. Ms. Ledger Fernandez, no. Mr. Chairman.
Aye.
Mr. Chairman.
Clerk will report
aye.
the total.
6 yeas, 2 nays.
And the ayes have it. And the motion to report is agreed to. Accordingly, Ms. Houchin will be managing the rule for the majority.
And me, I am doing it for us, yeah.
It'll be a worthy debate. Without objection, the committee is adjourned.